Welcome to the tutorial on public records law. My name is Courtney Bailey. I'm here with Whitney Ray.
Hello.
We are records analysts for the State Archives, a division of the Department of Natural and Cultural Resources. As records analysts, we help clarify public records law for local and state government employees, although we can't provide legal advice. In this video, we're going to talk about North Carolina public records law. There are many statutes that impact how public records are managed and made available, but we hope that at the end of this talk, you will know the definition of public records in North Carolina, your responsibilities as records custodians to fulfill public records requests, and how to navigate confidentiality restrictions. Whitney, would you mind telling our audience about General Statute 121?
Sure, Courtney. General Statute 121 is the Archives and History Act. It assigns records management responsibility to the Department of Natural and Cultural Resources. This is why our department publishes records retention and disposition schedules. These schedules identify and describe public records at the series level and provide instructions for the disposition of the records throughout their life cycle. It also is the reason behind why we provide training on records management and make videos like these.
Okay, but General Statute 121 is not the only one that governs records management in North Carolina. What about General Statute 132?
Yes, General Statute 132, the public records law, is very relevant to our responsibilities as records custodians. Records custodians are responsible for maintaining and providing access to records. GS 132 also defines public records.
So what is the definition of public records?
Public records are any materials, regardless of physical form or characteristics, created in connection with the transaction of public business. In essence, any document, data point, social media post, and email that documents the business of government is a public record. It doesn't matter who paid for the materials or what sort of media the record is composed of. What matters is that it documents a transaction of public business.
So that can include text on personal cell phones and direct messages on social media, right?
Yes. As long as it's connected with the transaction of public business, it is a public record.
What if a public record contains confidential information? Is it still a public record?
GS 132 has specific sections addressing confidential records. Personnel records, medical and mental health records, prison records, student records, blueprints for public buildings, and personally identifying information are all types of records with confidentiality restrictions. But even if a public record contains confidential information, it is still a public record. There are also additional state and federal statutes and laws that may apply, such as GS 130A-12 and HIPAA for medical records. It is important when dealing with confidential materials to know which statutes and laws apply and to be familiar with them. Sometimes confidentiality means that you are not required to provide access, but you can do so if you choose. Or it can mean that only certain people can see records, but to everyone else they are restricted.
So records can be restricted in certain contexts, but not others. Does confidentiality ever expire?
For most records, Courtney, yes. A fairly new provision in GS 132 states that confidentiality expires after 100 years for most records. But there are exceptions to this, including prison records.
Other than confidentiality restrictions, what do records custodians need to know about fulfilling public records requests?
North Carolina considers public records the property of the people and allows inspection by anyone. Records custodians are required to provide access to these records unless there is a confidentiality law restricting them. If you receive a public records request and there is a public information officer, public records manager, or other person in charge of these requests at your agency, be sure to contact them and/or your agency's legal counsel before responding to see if there are any issues of which you should be aware.
When do records have to be made available?
Public records should be made available during reasonable times, such as during normal business hours.
So that means you don't have to open the office at 11 p.m. to fill a records request.
That's right. You can also make records available online and in a format that can be easily downloaded. Then you can direct the requesters to find the records online. This works well for records that are frequently requested from your agency and fulfills the requirements of the law. Also, records requests should be filled as promptly as possible. We recommend having an internal policy describing how you deal with public records requests.
Can you ask the requester why they want the records?
If knowing why someone wants to see a record can help you provide them with what they want, you are free to ask. But you cannot require them to tell you, and you cannot use their motive as a reason to deny access. The requester doesn't have to tell you their purpose or motive for asking for the records.
And what about cost? Can you charge for a public records request?
In a public records request, The agency bears the cost of separating confidential from non-confidential information. It can charge for the cost of reproducing the records and in situations that require extensive personnel time or IT resources.
So we've covered the basics of North Carolina public records law, confidentiality, and public records requests. If you still have records-related questions, please contact a records analyst.
For more information, consult our website, archives.ncdcr.gov, and blog, ncrecords.wordpress.com. You can also contact us at 919-814-6900 or records@ncdcr.gov.